Good evening. In India, the punishments are given in the form of penalties, simple imprisonment, rigorous imprisonment, life imprisonment, and the ultimate one is the death sentence, or it is called capital sentence. But in majority of the cases, the Supreme Court held that only in the rarest of the rare cases, death sentence must be aborted. So, after looking at various alternatives, if the court feels that the person has to be hanged and there is no other alternative, then only the death sentence must be aborted. This is what is reiterated by the Supreme Court in one of the recent judgments. And I would like to share the information with you. Very important one and very frequently and seriously discussed topic in India. India is one of the countries in the world where we still impose death penalties, death sentences. So regarding that, I would like to share the information with you. Please have a look at this. So when it comes to the court, the Honorable Supreme Court said that death penalty should be resorted to by the courts only if the crime is an uncommon one. Very important one. And no mitigating circumstances of the convict should be able to overcome the aggravation or, for one, the brutality of the crime. The crime should be of a nature that leaves the court with the opinion that a life sentence would be inadequate. Meaning, if the court is convincing itself that for the crime that has been committed by the convict, if you award a life sentence, life imprisonment, that would be inadequate. Only in such circumstances, death sentence must be awarded. This is what the Supreme Court has said. Supreme Court also said that all murders are inhuman, but for imposing capital sentence, the crime must be uncommon in nature, where even after taking into account the mitigating circumstances, the court must be of the opinion that the sentence of imprisonment for life is inadequate. Very important one. Meaning, Supreme Court is cautioning the other lower courts, including the high courts, that don't jump onto the death sentence directly. Look for various alternatives and also take into account the mitigating circumstances. Look at the background. If there is any possibility of mitigating the this death sentence, then definitely you can go for it. And after verifying everything, even after that, if the court feels that there is no alternative but to impose death sentence, then only award death sentence, otherwise no. This is what the Supreme Court said. Clear? Very important one. And in most of the cases, the people will demand, certain people must be hanged immediately. And when it comes to the lower courts, they may be under the pressure and they will be awarding the death sentences, and that will be reaching to high courts and the Supreme Courts. Right. Look at this. So when it comes to this particular, the case, the Supreme Court said that the case was heinous and brutal, and it is related to rape and murder of 8-year-old girl by her uncle. Right? The court commuted death penalty of the convict to the life sentence with no remission for 30 years of the imprisonment. Meaning, lower court has imposed death sentence on that particular person, but Supreme Court commuted, meaning reduced death penalty to the life sentence, and there will be no remission for 30 years, and for 30 years he has to be behind the bars, right? So while Justice Ravi Kumar, who wrote the judgment, said that the nature of a commission of the crime, the victim being a relative, and the hapless situation of the girl, and shocking injuries found on the child were all aggravating circumstances. Meaning, according to this judge, Justice Ravi Kumar said very clearly, there are aggravating circumstances. Meaning, the court can get convinced that this particular person can be awarded death sentence because just 8-year-old girl, and the crime was committed by her own uncle, right? And the situation of the girl, and the shocking injuries found on the child, they were all aggravating circumstances. But the court also said, along with the aggravating circumstances, you should also look at the mitigating circumstances. Meaning, you are able to prove that this person has to be hanged. But on the other side, is there any alternative where death penalty need not be imposed, where life imprisonment is enough? Those mitigating circumstances must be looked into by the court. The undisputable fact is that the appellant had no criminal antecedents, meaning the person who got this death penalty, death sentence by the lower court, he appealed to the Supreme Court, and the Supreme Court verified the facts, and it found that that person had no criminal antecedents, and he hailed from a poor socio-economic background, and also his unblemished conduct inside the jail cannot go unnoticed. So also it is a fact that at the time of the commission of the offense, the appellant was aged 25 years. These are all the mitigating circumstances for the Honorable Supreme Court said, right? And the court said it cannot rule out the possibility and the probability of the reformation and rehabilitation of the appellant, meaning give him a chance for reformation, rehabilitation. So these are the various things that are observed by the Honorable Supreme Court. Look at this, the last point. The long and short of the discussion is that the present case cannot be considered as one falling in the category of rarest of rare cases. This is what is very important, my dear friends, and the Honorable Supreme Court observed this, in which there is no alternative but to impose a death sentence. No, there is an alternative, and that is the reason why the Supreme Court commuted death penalty to life imprisonment to this convict. Very, very, very important one. And kindly remember, as far as these type of information is concerned, so there are always contradictions. Some people, they always demand such people should not be spared and they should be hanged to death. But on the other side, the people who are considered to be the who work for the work on the grounds of humanity, they always fight, such people must be punished, but death sentence is not the solution. Throw them behind the bars for the entire life, right? And the Honorable Supreme Court has used the words rarest of the rare cases, and according to the court, this case will not fall under the rarest of the rare cases. That is the reason why the death sentence has been reduced to life imprisonment with no remission for 30 years. Kindly remember, these type of the cases are important, especially when you are writing the the main examination. maybe for UPSC or at the state level group 1 services. Thank you so much. I'll see you in the next session.